Dear students, Namaskar. Today I am going to discuss another very important chapter of our constitution which relates to inalienable human rights of a human being. Now, perhaps you are feeling confused. Okay, this is a new term for us because so far we discussed inalienable fundamental rights, but there is another important chapter which relates to inalienable human rights, and these rights are to be covered under the important chapter of our constitution, that is part 4th of the constitution, which talks about the directive principles of state policy. So far as we discussed that this chapter is equally important as the chapter of fundamental rights. Here, in case if we go to the history of directive principles, we can say that it's the fundamental rights and directive principle have a common origin. It was the Nehru report of 1928. Nehru report means Motilal Nehru report. In all parties conference committee report 1928, which was chaired by Mr. Motilal Nehru, and that's why it is popularly known as Nehru report. And that Nehru report contained a Swaraj Constitution of India, incorporated some fundamental rights, and these includes such rights as the right of elementary education. Then in 1945, the Sapru report of 1945 clearly divided the fundamental rights into two categories: justiciable and non-justiciable. Sir B.N. Rao, constitutional advisor to the Constituent Assembly, advised that individual rights should be divided into the two categories, and those which can be enforced by the courts and those which cannot be enforced by the courts. So the later he thought are moral precepts, means directive principles are moral precepts for the authorities of the courts, or so for the authorities of the state. And his suggestion was accepted by the drafting committee. As a result, all of you know that we have fundamental rights under part 3rd of the constitution, which are justiciable, and directive principles under part 4th of the constitution, which are non-justiciable. The objective of the was securing social, economic, and political justice and securing the dignity of individual as well as welfare of the individual by establishing welfare state. So our constitution makers followed the model of Constitution of Ireland, and Ireland had adopted it from Spanish Constitution. And this Ireland Constitution or our Constitution, which was borrowed from Ireland Constitution, sets forth certain principles of social policy for the guidance of state, but which are not cognizable by any court. Here, in case if we talk about the objective or underlying objective behind the directive principles are the ideals which the union and the state government must keep in mind while they are formulate any kind of policies and while they are going to enact any kind of law. Here, in case if we talk about in the words of one expert, Jane Joshi, they constitute a very comprehensive political, social, economic programs for a modern democratic state. And in case if we talk about the objective behind the directive principles, which has been underlined by Dr. Ambedkar, that our constitution lays down what is called parliamentary democracy. Parliamentary democracy, we mean one man, one vote. And we also mean that every government shall be on the annual both in daily affairs and also at the end of certain period when the voters and electorate will be given an opportunity to assess the work done by the government. Because sometimes one question is to be raised: fundamental rights are justiciable by the courts, enforceable by the courts, whereas directive principles are not enforceable by the courts. And the chapter of directive principles, by adding chapter of directive principles in our constitution, which makes our constitution little bit more bulky constitution, it was totally meaningless. Some raised this question. But the incorporation of directive principle in our constitution is not a meaningless. Although directive principles are non-justiciable, in the light of parliamentary democracy, they are, or rather we could say, they had been, they have been, and they are, and they will be constant reminders for every vigilant government, every responsible government, every accountable government, for having importance of these directive principles in making or having importance as and when the government is going to formulate the policies or going to make the laws, because these these principles talks about the social democracy, economic democracy, and political democracy. And that's why it is clear that the main object in enacting the directive principles appears to have to set standards of achievement before the legislature and the executive and local authorities or other authorities. Means as we discussed that under Article 12, which defines the state, so it is constant reminder, or its directive principle has been set out standards of achievements. So it also hoped that those failing to implement the directive principles might receive a rude awakening at the times of polls. So it should, however, be noted that directive principle do not impose any particular branch or pattern of economic or social order. They lays down the goals which may be achieved through various means which have to be devised from time to time. Because the contents and meaning of directive principles are not absolute and rigid. All those are to be interpreted in the light of changing scenario of the society or time to time. And in case if we talk about the classification of directive principles, the directive principles may be classified into these groups. First, social and economic charter under Article 38 and 39, which talks about the distribution of justice, because it's Article 38 and 39 embody the jurisprudential doctrine of distributive justice, and the Constitution permits and even directs the states to administer what may be termed as distributive, distributive justice, and the concept of distributive justice in sphere of lawmaking interpret inter alia the removal of economic inequalities, removal of economic inequalities, rectifying the injustice resulting from dealing and transactions between the unequals in society. So, social order based on justice. Its Article 38, Clause 1 provides that states shall strive to promote the welfare of people by securing and protecting as effectively as it may social order in which justice, social order. What do you mean by social order? Social order means law and order, social order, social justice. Social order means social justice, or social order means which talks about the social justice, economic justice, and political justice, and shall inform all institutions of national life. So, directives only reforms that what has already been said that in the preamble also talks about to dispense the justice, that what should be the function of any democratic republic. The function of democratic republic to dispense the justice, and to dispense the justice of social justice, economic justice, and political justice. And that's why it's the 44th amendment which inserted one clause to Article 38 of the Constitution, which provide that states shall in particular strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities, not only amongst the individuals but also amongst group of individuals or group of peoples residing in different area or engaged in different employment or vocations. So this new clause aims at equality in all sphere of life or all spheres of walk of life. So it would enable the state to have a national policy on wages and eliminate eliminate inequalities in various spheres of life. And you know that with the Supreme Court, and in case if we talk about the social order, social order is having a wide amplitude which includes law and order, public order, as well as security of the state, and are not common meaning and connotation. So, so the term social order has a direct nexus with the preamble of the Constitution, as we discussed, that which secures social justice, economic justice, and political justice to the people of India. And it is doubtless, it is unambiguous, or we can say it is unequivocal, unequivocal, equivocal, unequivocal duty or doubtless duty of the state and its organs to preserve peace, public peace, public safety, public tranquility, and public order. To ensure social security to the citizen of India, state is merely under the legal duty. But there is a constitutional mandate also, not only under legal duty. So the court normally are little bit reluctant. Generally, they don't interfere in the administration of law and order of the society until unless they are not forced by the compelling reasons arising because of the compelling conditions and circumstances of the society. Now, it's Article 39, which is very, very important article. And Article 39 has been remained in controversy because of its vital importance. As all of you know, Article 39 is to be enforced, is to be followed by the states for securing economic justice. And Article 39 specifically require the states, ask the states to direct its policies towards securing the following principles. First, equal right of men and women to adequate means of livelihood. Means Article 39A talks about the equal right of men and women to adequate means of livelihood. Next, very important right that is to be covered under, or very important, we can say, interests, which is to be covered under Article 39B. Distribution of ownership and control of material resources of community to common goods. And Article 39C to ensure that economic system should not result in concentration of wealth or concentration of money and means of production to common detriment means that there should not be the concentration of money in few hands, because that will become a tool for detriment to the common goods. And that's why both Article 39B and C has been remained in its controversy. In various case law also we discussed, and I will again refer all those case law which were relevant to Article 39B and C. Now, Article 39E and F, as I have got referred these articles in my last lecture, under Article 23 and 24 of the Constitution, because what's the root? Right against exploitation. The root of right against exploitation lies under Article 39E and F of the Constitution. And we discussed it in detail yesterday also, in my last lecture also. And in case if we talk about Article 39B and C, again we can have a lot of discussion on 39B and C. Then another important provision, it is the provision of Article 39D. 39D, which were inserted by the Parliament by 42nd Amendment, or by one enacting by one act. It was the Parliament has enacted the Equal Remuneration Act 1976, because Article 39D talks about the equal pay for equal work, and that's why, because of the importance of Article 39D, in few landmark cases, that like your Ranveer Singh versus Union of India, in which the Supreme Court held that the principle of equal pay for equal work do not a fundamental rights, but is certainly a constitutional goal, and therefore capable of enforcement of through constitutional remedies under Article 32 of the Constitution. So the doctrine of equal pay for equal work is equally applicable, applied on a daily basis also. So we can say that it is because of the importance of Article 39D that they are also entitled to the same wages as other permanent employees in the Department of Applied into the. However, you know that there may be reasonable classification because of the nature of work, because of the varying nature of duty. There may be the variance of or exception of equal pay for equal work. It is because sometimes that it is because of the status, because of the hierarchy in particular department, that but equality among equals, reasonable classifications. So that's why, although this is right, although finds place Article 39, but it is an the it is subject to Article 14 and 16 of the Constitution. So that's why in other cases also, we can say employment of children, Article 39F, as we discussed, that in our last lectures, that although now there is a provision of the employment of the children below the age of 14, and by 42nd Amendment, emphasis of constructive of the state with regard to the children, and as we discussed in last semester, last lecture, MC Mehta versus State of Tamil Nadu. MC Mehta, you know that that which was totally based on the provision of children below the age of 14 in hazardous employment. Either it relates to the factories or relates to the mines, or etc. And in MC Mehta versus State of Tamil Nadu, known as a child labor abolition case, in which the Supreme Court has issued appropriate guidelines or directions to the government to take steps to abolish the child labor. And the detailed guidelines have been laid down by the Supreme Court in that landmark judgment. So we can say the verdict gives, various decisions gives by the Supreme Court time to time, gives a new hopes to the children of the country, that the benign, that the beginning is being made to honor the mandate of Article 24, 39A, 39B, 39F, and another provision also, we can say Article 45, compulsory free education, we discussed in our last lecture, and 47 of the Constitution. Now another important article which provides social security, and which is also known as Social Security Charter, and covered under Article 43A of the Constitution. It talks about 43A talks about participation of workers in management, and this Social Security Charter also talks about right to work, education, and public assistance in certain cases because it's Article 41 tax the states to ensure the public, to ensure the people within the limit of its economic capacity and development, employment, education, and public assistance in cases of unemployment, old age, sickness, disablement, and in other cases of undeserved wants. Just and human conditions of work. It's the mandate of Article 42. Then another important provision which gives social security, that is living wages for workers, and it's the mandate of Article 43 that it's the duty of the state that by enacting suitable legislature, suitable legislation to provide a living wage for workers. Article 43 refers to living wages, not minimum wages. The concept of living wages includes, in addition to bare necessities of life, food, shelter, and clothing, provision for education of children and insurance, etc. And I won't run after important article. I won't run uh, in detail, as we have got discussed a lot about the very important article, that is Article 45, which talks about the free and compulsory education till the age of till the completion the age of 40. And as we discussed, that because of the landmark judgment Unnikirsan versus Andhra Pradesh, state of Andhra Pradesh, in which the Supreme Court held that the right under Article 45 is not a simple interest, but that can be declared as a fundamental rights, and that's why the government or the parliament introduced 86th constitutional amendment and inserted 21A in our constitution. And you know that we discussed the provision of 45 as well as provision of 21A and provision of 2009 Act, which was enacted for the purpose of enforcement of the provision of 21A. In detail, in Pramati, Educational and Cultural Trust versus Union of India in our last lecture. Next, duty to raise the standard of living and improvement of health. It's the mandate of Article 47. Next, the promotion of educational and economic interest of the weaker sections. It's the mandate of Article 46 of the Constitution. And next, very important article, which was to be taken as directive principles, but now, because of that, the importance of that important article, now the provision has been declared as a fundamental rights of the citizen. It's Article 39A. 39A, all of you know, taxed the states to ensure that operation of legal system promotes justice on a basis of equal opportunities and shall in particular provide free legal aid by suitable legislation or schemes in any other way to ensure that opportunity for securing justice are not denied to any citizen by reason of economic or other disabilities. And all of you know now the legal aid and speedy trial has been declared as a fundamental rights under Article 21 of the Constitution, and we have got discussed under Article 21 a lot of cases which are related to speedy trial, which were related to legal aid and speedy trial, like landmark judgment M.H. Hoscott versus State of Maharashtra, Husinera Khatun versus State of Bihar, and again I would like to recall the importance of these judgments. By these judgments, in these judgments, the Supreme Court declared legal aid as a fundamental rights and speedy trial as a fundamental rights under Article 21 of the Constitution. It was because of the mandate of important landmark judgment Menka Gandhi versus Union of India. So again, there are another important case law which are related to these important this important article or this important fundamental rights on legal aid and speedy trial, like Central of Legal Research versus State of Kerala, another State of Maharashtra versus Manubhai Paragji Vashi, in which you know that legal aid and speedy trial, because both are interconnected to each other. It's the 39A which had given birth to the legal aid, and it's the legal aid which is totally connected to the speedy trial, because and speedy trial connected to the justice. So that's why, in case if there is no provision for legal aid, then we can't dream about the speedy trial. And in case if we don't provide speedy trial, we won't be able to dispense the pious goal of our justice. Either it is social justice, or economic justice, or political justice. So it has been always uh, stressed by the courts that there has to be a lot of programs for creating more and more awareness amongst the people for speedy trial or for legal aid. And the Supreme Court time to time has directed the governments to establish more and more law colleges, law universities, so that the people could learn more and more about the prevailing laws. And you know that there is one important sentence also, that every citizen of the land must know the law of the land. And It would be possible only as and when governments are going to establish more and more black colleges or allowed to establish private colleges and also provide them economic aid for the sustainability or survival of these black colleges so that they could provide good quality of legal education to the generations and coming generations. Another important article which has been always remained in controversy also, that's Article 44, which requires a uniform civil code that the state to secure and I won't uh, give, but I would like to give and give a reference of few important landmark decisions, and I think all of you must have been gone through all those landmark decisions because of the importance of Article 44 of the Constitution, which relates to community welfare, which relates to community welfare charter, and that is the provision of uniform civil code, which has been discussed by the framers, constitutional framers, under Article 44 of the Constitution. And you must have been gone through under your family law one important case law, that is Sarla Mudgil versus Union of India. And the Sarla Mudgil versus Union of India was decided in the light of the importance of Article 44 of the Constitution. Like that, another decisions, Pragati Varghese versus Cyril George Varghese, which relates to uh, one Indian Divorce Act, that which was struck down Section 10 of the Indian Divorce Act, which was related to the Christians, and that was proved discriminatory for a Christian lady in the light of 44 constitutional, in the light of 44 article of the Constitution. Then again, Noor Sabha Khatun versus Muhammad Qasim. Then again, yes, another important or landmark judgment I would skip to mention, which was decided in 1985, Shabano case. And in that case, that even Supreme Court has remarked that it's the duty of the government now to enforce the contents of Article 44, which talks about the Uniform Civil Code and which had created a very hue and cry in the society. Because of that, the laws were amended by the Dadan government, and after that it is Salam Mudgil. Then it's Noor Sabha Khatun. Another case, Daniel Latif versus Union of India. Again, we can say that it is another important case which has been decided by the Supreme Court in the light of Article 44 of the Constitution. Then Wal, John Walmerton versus Union of India, 2003 case, which was decided by the Supreme Court in the light of Article Article 44 and another important provision of the Constitution like Article 25, 26 of the Constitution. So in that case also the Supreme Court has emphasized that it is a matter of regret that Article 44 of the Constitution has not been given effect. A common civil code will enhance the cause of national integration by removing the contradictions based on ideologies. And another very important decision delivered by the Supreme Court, and we can say it was the first step towards uniform civil code, that all marriages must be registered, and these directions were given by the Supreme Court because of the importance of Article 44 of the Constitution, because this ruling will benefits to prevent child marriages, means that this ruling will prevent child marriage. This ruling will have check upon bigamy and polygamy. This rule will help to women to exercise their rights in marriage, maintenance, custody of children. This rule to enable widows to claim inheritance, and this rule also deterred the husbands from deserting their wives. And you know that it is a very important provision of our constitution which talks about the uniform civil code. And another article which has been inserted by 97th Constitutional Amendment, that is Article 43B, which talks about the promotion of cooperative societies. Article 48, another provision, organization of agriculture and animal husbandry, and which talks about that it should be steps for the preserving, improving the breeds, and prohibiting of slaughter of cow and calves and other milch and draught cattle. And another very important provisions, that is covered a directive principle, that is the provision of Article 48A, which talks about the protection and improvement of forest and wildlife. And you know that it is because of this provision, the lot of PIL has been filed by the various uh, activists like MC Mehta for the protection of the environment, for the protection of the forests, for the protection of uh, wildlife by another PIL activists. And there are other cases also, that which can be cited. It's TN Goda Verma Thirmul Paul versus Union of India, So another important provision of directive principle that is to be called under Article 50 of the Constitution. Article 50 talks about to separate judiciary from executive, separation of judiciary from executive in public services of state to promote the rule of law. And this is very, very essential. And now, not only the separation of judiciary from executive, but now all of you know that in our legal system, the separation of powers between legislature, executive, and judiciary has been considered, has been recognized as the basic structure of the Constitution. Another provisions we can say that it's Article 50, promotion of international peace and security and protection of human rights. It's because of Article 51, 51 of the Constitution, because you know Protection of Human Rights Act 1993. It's because of the importance of Article 51 of the Constitution. Then Article 40, which talks about the organization of village panchayats, and it's because of the Article 40 that we have got introduced 73rd and 74th Constitution Amendment, which talks about the provision of Panchayati Raj. Now, in case if we talk about the relation between fundamental rights and directive principles, then again we can recall a lot of series of famous judgments which has been delivered by the Supreme Court time to time, and almost all those judgments so far we have got discussed, like your state of Madras versus Champakam Dorajan, as, as you know that because of the directive principle policy and because of the importance of Article 37, because Article 37 directs that the state will take an account of directive principles as and when they will be formulating the policies or enacting the laws. And you know that we discussed that it's the Champakam Dorajan, and because of the decision of the Champakam Dorajan in first constitutional amendment, clause 4 was inserted to Article 15 of the Constitution, which talks about the special provision for socially and educationally backward class and scheduled castes and scheduled tribes. Another case we can discuss, that's for the purpose of social justice, socio-economic justice. The government had tried to introduce agrarian reforms for achieving the goal of socio-economic justice and introduced the land reform laws, which were supposed to abolish the jamidari system or jamidari partha. And the first case, all of you know that we discussed in detail so many times, it's the Kameshwar Singh versus state of Bihar. And another important case law, which was discussed in 1957, very important case law, in which in which the relation between uh, directive principle and fundamental rights have been very beautifully illustrated by the Supreme Court. It was the case of Kerala Education Bill, where the Supreme Court observed that though the directive principles are though the directive principles cannot override the fundamental rights, nevertheless, in determining the scope and ambit of fundamental rights, the court may not entirely ignore the directive principles, but should adopt the principles of harmonious construction. Harmonious construction of harmonious construction and should attempt to give effect to both as much as possible. So, likewise, a state law, which that state law. So that's why uh, uh, you know in many of the cases, the Supreme Court applied this approach, and again you can cite another uh, important case law in which the relation of directive principle and fundamental rights has been uh, prescribed by the Supreme Court. The landmark case, Keshwanath Bharati versus State of Kerala. Supreme Court uh, has said that fundamental rights and directive principles aim at the same goal of bringing about a social revolution and establishment of welfare state, and they can be interpreted and applied together. And how they can be interpreted and applied together? Only because of the harmonious construction. So they are supplementary and complementary to each other. So it can well be said that directive principle prescribed the goal to be attained, and fundamental rights lay down the means by which that goal is to be achieved. So it has been mentioned by the Supreme Court in Keshwanath Bharati. Another relation, as you know, that it's as I got mentioned right now, also Unnikirsan case. Then you can cite here the relationship between fundamental rights. That it's the case of State of Bombay versus FN Balsara, where Supreme Court has gave weight to Article 47, which directs the state to bring about prohibition of consumption and intoxicating drink except for a medical purpose. So, to support its decision that the restriction imposed by the Bombay Prohibition Act was reasonable restriction. And another, as right now I have got cited the importance of Article 39B and C, and we have got discussed a lot about the importance of Article 31C. Article 31C was inserted by the Parliament by 25th Constitutional Amendment, and Article 31C had two parts. First part talks about that the directive principle contained under Article 39B and C will be having primacy over the fundamental rights under Article 14, 19 and 31 of the Constitution. And that it was, and the second part was related to that the primacy will not be subject to a question in a court. But it was related to the second part. And in Keshwananda Bharati case, we discussed that the first part was declared constitutional and valid, but the second part was not declared constitutional and invalid. And by 42nd Amendment, all of you know that the Parliament has again Parliament had amended Article 31C, and where the Supreme Court, where the Parliament had given primacy to all directive principles over the fundamental rights under Article 14 and 19. And you know that here the Supreme Court has not upheld it because of the again reiteration of the principle of that the directive principles and fundamental rights are complementary and supplementary to each other, and the balance and the harmony and balance of the both are the bedrock of the Constitution, or the balance of the both are the conscience of the Constitution. And again, the 31C was discussed in another case, Sanjeev Coke Manufacturing versus Bharat Cooking Coal Limited. And in that case, also you know that we discussed the importance of 31C. And again, you are having the rights with the 39B and C, State of Tamil Nadu versus L. Abu Kumar Bai. And there are another important decisions also, as we have got discussed that decision also, State of Gujarat versus Mirzapur Moti Qureshi Kasab Jamaat, in which you know that because of the prohibition of slaughter of cow and progeny, he challenged that it's the violation of article or his right under Article 19 G. The Supreme Court held that that in the light of in the light of Article 37 and Article 48 of the Constitution, there is no violation of rights under Article 19 G, because he had another options also. He could have the profession of slaughtering of a cattle other than cow and progeny, because that is the backbone of Indian agricultural economy, etc. So here again, I have got cited Unikrishnan, and then directive principle given status of fundamental rights. Unikrishnan, all of you know that it's the Article 45 now has been resulted into 21A. Then it's Article 39D, which gives equal pay for equal work. Ranadhir Singh versus Union of India, equal pay for equal work. Then M.H. Hoscott, Husainera Khatun, it's 39A, which now talks about the legal aid and speedy trial is a fundamental rights. Then another case, Grit Kalyan Kendra Workers versus Union of India. So this case, which relates to Article 39D, and you know that which talks about the enforcement of legal aid, and so 39D, 39 not A but 39D, which talks about equal pay for equal works. And another case, we can say that it's the case of MRF Limited versus Inspector of Kerala, which relates to which relied upon the Article 43 to uphold the validity of Kerala Industrial Establishment National and Festival Holidays Act held that act is an social legislation to give effect to the directive principles of state policy contained in Article 43 of the Constitution. And again, we are having Gujarat Agriculture University versus Road Hod Labu Parachar, that the workers who had been continued for more than 10 years, their services were, the Supreme Court's past direction that their services must be regularized. In the light of the court observed the government who is a guardian of people and obliged under Article 38 of the Constitution square social order for promotion of welfare of the people to eliminate inequalities in the status. Will endeavor to give maximum force even at the first stage of absorption. So we can say that all these fundamental directive principles are elevated to the inalienable fundamental rights. They are enforceable by themselves. Directive principles in our constitution are forerunner of UNO Convention of Right to Development as a inalienable human rights, and every people is entitled to participate and contribute to and enjoy economic, social, cultural, political development in which all human rights fundamental freedoms would be fully realized. So it is the duty of the government or responsible to the government for further development of human rights, and it is the duty of the state to take an account of the implementations or for implementation of directive principles seriously and devotedly uh, for the development of the society, upliftment of the society, and for securing the pious ideals and goals or objectives which has been expected or had been expected by the framers by incorporating these pious directive principles under the part 4th of the Constitution. That they are having their importance, they had their importance, and they will be importance. They will be having their importance in future also. And for today, it's all for today's discussion. That was related to directive principles. Dear students, in case if you are having any doubt, then kindly again I request that you kindly ask to Mr. Mann or to Mr. Agarwal to organize a meeting on video conferencing or Zoom, etc. Thank you.